Yeah, it's a pleasure and privilege for me to host today's session. We have a very practical issue on money laundering, and we'll have an interactive session after we look at presentation, deep dive into many case studies. Uh, it's a pleasure to me for me to be out here. Uh, we have a very eminent speaker who has studied the subject of money laundering case studies, very important landmark cases, who will share the presentation and share experiences. Mr. Shio Dayal Chand is a retired IRS and advocate. He has worked in Indian Customs and GST for over 30 years experience in several formations of Customs and GST, has held the position of Joint Directorate ED for West Bengal and Northeast for 4 years, and also additional charge for UP for 1 year. I would like to state a very important honor Mr. Chand has received. On the Republic Day 2011, Mr. Chand was awarded the Presidential Award for his meritorious services. It's really a great honor to get the Presidential Award for Meritorious Services. Mr. Chand has expertise in customs valuation and also a trainer on customs valuations by World Customs Organizations, and traveled to over 15 countries for training and related areas. Mr. Chand has headed the creation for Customs Valuation Database, NIDB, very important database, and has assisted several African countries in setting up customs valuation databases. Very important work. He has also handled several important cases like Sharda, Rose Valley, Narda during his term as executive director, ED. The team headed by him has attached thousands of crores worth proceeds of crime during his term as ED. He is a regular faculty at NACEN. He has addressed several chapters, especially Calcutta chapter of the Institute on PMLA, and look forward to a wonderful interaction and a presentation. Mr. Chand, over to you.
Thanks, sir, and thanks for the kind words you have expressed. I will try to prove myself to the words which you have mentioned to your all these people who are listening us. I am told today is the result of chartered accountant has also come. Institute, this is final results has come, and if there is anybody here who can who was there, I must congratulate them for this. And now I will start my presentation. See, PMLA, basic thing is that it is a blend of civil and criminal action. All criminal actions are already punishable under some act or other. But where the problem lies was that the proceed of crime, the money remains with the accused, with the criminal. And with the help of that money, he was using this legal system, misusing the legal system, and was trying to hoodwink all the process of law. So basic thing was that proceed of crime was an arm and ammunition in his hands through which he was guarding himself. So worldwide, basically it was, initially it started with drugs, arms and ammunition like this. So it was that this major arm and ammunition, that is the proceed of crime, the money, he should be deprived of this at the initial stage, so that he cannot use that very proceed of crime to save himself. So that is the basic purpose, because the crimes were already punishable. But what was the reason why the PMLA has been introduced? in over and above the criminal law, which is already punishing the crime. So here it is a blend of civil and criminal law. In addition to mechanism provided in the Act, it is governed by several provisions of CRPC, and for other issues, it is governed by Income Tax Act and rules made thereunder. Because see, all law, everything cannot be introduced in one act. So for the investigation purpose, the rules and regulations prescribed in the Indian Customs Act for civil matters, it has been taken, adopted. And similarly, when the criminal issues comes, it is the we have adopted the CRPC provisions for in the PMLA itself. Some cases where the PMLA is giving some procedure, some rules, that then it will override the CRPC and the income tax provisions. Now let us see what is civil action we are taking. Attachment of proceed of crime. As I have in the introductory part, I have said, the most important thing, most important arms and ammunition the criminal is having is the money. So what we do, attachment of proceed of crime. And what is proceed of crime? It has been defined under section 2U, and attachment is done under section 5 of the PMLA. We will be elaborating it. You must have been, yes, so 2U, what is 2U and section 5, I will be elaborating. The first thing is that attachment of proceed of crime. Second is that seizure of property or document. Suppose the ED team has visited somewhere and recovered something, some documents, some money, cash, and other things. These are to be seized. And once the seized, they are required to be confiscated also under the provisions of law. So under civil action, what we are doing? We are attaching the proceed of crime either in the way of provisional attachments or by the seizure of the property during course of search and personal search or the premises search. So this is the civil action we are adopting. Criminal action. Money laundering itself is an offense as defined in section 3 of the PMLA, and it is punishable under section 4 of the PMLA. For this, for like any criminal law, the trial has to be, so there are special courts nominated by the High Court who conduct the trial of money laundering. So this is the, and the maximum punishment is 7 years. But in case it is related to drugs, the maximum punishment goes to 10 years. And then in the civil action, we have said that attachment, seizure, but attachment and seizure doesn't empower government to occupy or confiscate it. For that, this PMLA court, special court PMLA court, has to pass an order of confiscation. So whatever has been attached or seized under civil actions, they are all confiscated under this criminal action under section 8(5) of the PMLA. And so in addition to the confiscation of 8(5) of the PMLA, a property involved in money laundering or which has been used for commission of offense of money laundering, including the attachment under section 5 of PMLA or seized under section 17 of the PMLA. So just for repetition once again, criminal action. I will say that a lot of things are being heard about the PMLA, ED, but unfortunately, the criminal cases which has been filed against the accused in pan-India level, hardly 20 to 25 cases have been disposed of till date. It is a new act, you know, it was introduced in 2002, 2003 actually, and then it actually came in power in 2005. After investigation and then filing of the prosecution complaint, hardly 20-25 cases disposals has taken place so far by the special PMLA court. And in most of the cases, accused has been convicted, and in few cases, acquittal has also been done. But there is no finality. Why? Because all these matters are pending at appellate forum. Suppose the special court has already convicted or acquitted, the matter is lying in the High Court, High Court, and hardly any precedent can be drawn from these cases. Anyway, it is going on. But when we talk about civil action, the civil action is the where the dent of ED is felt by the criminals. Property was several thousands. I will say more than 70,000-80,000 crores have been attached so far, and thus depriving the accused enjoying fruits of crime. I will just tell you that property worth more than 10,000 crores has been attached only in Vijaya Malia case. The market value will be around 15 to 20,000 crores in only one case. In Nirav Modi case, it is more than 7,000 crores it has been attached. So it is here the real dent comes and real effect of this PMLA comes. Once whole thing is all your property, all your money is attached, you become okay. So this was some preliminary issues because my topic today is case study. So I should move to few case studies, important or landmark case studies. One case it has been investigated. It was investigated by my team, and I take it as one of the initial cases where the prosecution has been filed, it is pending. What was happening? Maybe you might have read in the newspapers and other places that there is a lot of cattle smuggling in the Indo-Bangladesh border. This person, whom we are going to discuss in detail, he was smuggling cattle to Bangladesh, and he was getting sale proceeds there. The sale proceeds were bringing in the form of gold. He was smuggling in, smuggling out both. Smuggling out cattle, smuggling in gold. So this is a case where which I thought that I should be presenting to this August gathering. One more thing I will, I understand that we are talking about proceed of crime. So there should be a crime. And which crime? Not all crime. Crime which are scheduled to the PMLA, which are listed in the schedule to the PMLA. So that is, must be a crime. Without crime, there cannot be a PMLA. Yes, once the crime has been triggered, even if the crime we will discuss in detail, the case is discharged or acquitted, even then PMLA case will continue. So here must be a trigger by way of a scheduled offense. In this case, what has happened? On specific input, officers of DRI intercepted one SUV at the outskirts of Calcutta. There were one passenger, one driver. On search of the vehicle, DRI officials recovered around 44.7 kg of gold of foreign origin, valued at around 13.5 crores from the cloak compartment and also hidden below the seat. So what was the offense? Smuggling of gold. And then one Beretta pistol and some Indian currency was also seized from that is. During interrogation by DRI, both the persons admitted that they were actually involved in smuggling of gold. For their involvement in smuggling, both the persons were arrested under Customs Act but released on bail immediately by the court. This person was a very influential person and he was arrested on a holiday. Normally in customs matter or any special law, the holiday magistrate doesn't give bail. That is the customary, what he is doing was giving a 1 day or 2 day remand, and then the accused is to be produced to the special court for that, because for customs there is a special court, for PMLA there is a special court. So normal magistrates normally doesn't give bail. But in this case, because of his influence, because of his clout, he was given bail immediately. So investigation indicated that the arrested person was kingpin of cattle smuggling racket on Indo-Bangladesh border. He used to smuggle out cattle to Bangladesh, and gold recovered from them were sale proceeds of the cattle, and same has been smuggled from Bangladesh. So that is the offense. During investigation of DRI, So when he was granted bail, DRI has also took vengeance and he was detained under Kohiposa. He remained in jail for few months. After completion of their investigation, so-called notice was issued by DRI against both the accused person. And for their criminal involvement, a prosecution complaint was also filed in competent court under Section 135 of Customs Act. So, those my friends, those who are well versed with the customs matters, that there is a so-called notice for confiscation of the goods and imposing a penalty, and for in serious matters, criminal complaint is filed, and for that there is a punishment of jail and other things. So both things was done in his case. Now the Section 135 of Customs Act is a scheduled offence under PMLA. So Section 135 of Customs Act is a scheduled offence. A case was registered at Kolkata ED office and inquiries were initiated under PMLA to locate the proceed of crime acquired out of the commission of scheduled offence. Friends, that gold was already there with DRI. They have seized it there. So in addition to that, whatever he has earned out of this his crime, criminal activity, that we were looking after. The accused persons were taken into ED custody, examined, inquiry was then. For this purpose, inquiries were conducted with customs, income tax authorities, mobile operator, banks, district sub-registrar, police, BSF, these agencies from where we can find out is there any property and what is activity he is doing. So from these all agencies, we have conducted inquiries. Now let us come one by one. Inquiries with BSF revealed that the main accused person was the kingpin of cattle smuggling racket at Indo-Bangladesh border. He, through his henchmen, were involved in smuggling of cattle. Several FIRs were lodged against him by BSF to the police. BSF is guarding the borders. So they have lost, but they have no power to prosecute anybody. Prosecution is done by the state police. So they have lost FIR before in the state police. This person was having political as well as money power, political clout, all those things. He was not charge seated in a single case. But a very funny situation. The closer report says that his father's name was not there, so we could not locate the person. Every person in that area knows who is the person, but they closed on this count. And moreover, what is happening? He himself was not going there. His people were going, and the people who were caught, they were just petty leg workers. They will not take his name. And so he was always safe and he was never caught. But even the wisest person commits some mistake. In this case, what has happened is that there were 16 bank accounts which came to our notice. These all accounts were in the names of friends, relatives, concerns of the main accused person. They were in the other's name. How to find out a linkage with this person? During course of investigation, it was revealed that the one common mobile number was used to open all these bank accounts during the period from April 12 to August 13. That is 16 months. So all these 16 accounts were opened during 16 months. And every account has to be linked with some mobile number, and their single mobile number was used and linked to all these 16 accounts. And that was the thing which has we could nab him and we could connect him with all these accounts. Huge amounts in cash totaling rupees 109 crores were deposited in said accounts during April 12 to Feb 30. That is in a month of hardly 10 months. In 10 months, 109 crores were deposited in the said accounts. We could not understand why he has done. I will tell you just what was happening. What we came to know, there was a bank, some private bank, and the manager was very close to this person. He told him that no, you deposit the bank if you deposit in the bank, and then your turnover will increase and something and then everything was rewarded. And for this work, his organization has rewarded him. In fact, when he was rewarded and he was sent to Singapore for a week holidays by the bank. for bringing this type of huge big account. Now he was very angry with this person that he has befooled me, and for his own career prospects, he has asked me to deposit this money in the bank, and now I am in soup. All these amounts were deposited, withdrawn in cash during November 12 to July 13 and siphoned off to unknown destinations. Once the withdrawn in cash, it is very difficult to trace the money wherever it has gone. Yes, we could trace some properties purchased by him and other things. Anyway, that they were to unknown. Investigation with the concerned account holders revealed that the accused person was the beneficiary owner of all these accounts, and they had only signed some papers at the instance of the main accused, and they did not know the source or destination of the cash deposited and withdrawn from these accounts. So they were just named lenders, they were his workers, and the same persons who were carrying the cattle to the Bangladesh. And they said, no, sir, I don't know. He has asked me to sign. We have signed it, and he only knows. However, one or two person, his wife and his one brother, they were trying to act smart. No, it is agricultural income, and they were trying to justify their ITR were not commensurate cash deposit during the period, and they could not justify. Anyway, they tried to defend. As a result, we have not made those persons who said that I don't know accused, but these two persons who have tried to defend them said that it is my money, it is my legally earned money, they were made accused in the matter. So now money laundering. The proceeds of cattle smuggling was brought back in the form of gold from the Bangladesh. That is the earning of the proceed of crime. The sale proceeds of gold were deposited in these 16 bank accounts, that is the placement of the proceed of crime, and cash from the bank accounts were used to purchase cattle for smuggling purpose, because the money has come from the proceed of crime. Now he has to purchase further cattle, and then he can only smuggle it out. So it was used in purchase of the cattle, and the profit was used to purchase land in different names, thus completing the cycle of money laundering. So this is the layering part. This is the now what action ED has taken? Properties acquired out of proceeds of crime were provisionally attached under PMLA. These properties were attached. These were despite several cases at different courts filed by the accused person and being represented through the best of the lawyers, the said PO provisional attachment order was confirmed. Now one more twist is there. During course of the hearing of the provisional attachment order before the adjudicating authority, there is an adjudicating authority who confirms the provisional attachment orders. He was advised by a very senior counsel that we should do something to prove that it is our legally earned money. The accused person submitted revised ITRs and tax payment challans of the payment of IT of 5.5 crores. He has deposited 5.5 crores as tax, which casted further doubt. We extended our investigation, and we investigated from the records of the income tax authorities. It was revealed that the taxable income and taxes were revised manyfold just to hoodwink the authorities that he had a genuine source of income and out of which he has paid the taxes. He has paid this all amount from August 15 to December 15. All this amount was paid by him. This total around 5.5 crores. He has paid around 5.5 crores worth of tax. And how he has revised his returns, that is this page. Original ITR was 2008-9, was income shown was 1,60,000. He revised it to 1 crore 23 lakhs. The last one is very funny. His original return was 20 lakhs. He made it 5 crore 63 lakhs. He revised his returns, and whatever the excess income he was showing, on that he has paid, and plus interest, he has paid around 5.5 crores. We ask him from where you are, okay, forget about whatever you have, from where this 5.5 crore has come. that also become, he could not produce from where it has come, and that was added in the proceed of crime. That 5.5 crore was added in his initial 109 crores of proceed of crime. And this led to believe that, and then this was a very good case before the adjudicating authority. So because he said that even during PMLA investigation, you are indulging in money laundering activities by projecting the proceed of crime as legally earned money and paying income tax. It has become a copybook case, because normally we don't get matters where the person is projecting his ill-gotten money as a legally earned money. Here was the case where he was projecting his ill-gotten money as a legally earned money. So this was, somebody has ill-advised him, and he fell in the trap. After completion of the investigation, prosecution complaint was filed before the special court under section 45 of PMLA, and offense under section 3 of cognizance has been taken. And in fact, we have moved for cancellation of his bail for purpose of custodial trial. Let us conclude this. Predicate offense was only of 12 crores, whereas 12 crores of gold which was seized by the DRI. Whereas the amount involved in the money laundering identified was 109 crores, the amount which was deposited in his 16 accounts. And in addition, I will say 5.5 crores deposited by him for his income tax is also proceed of crime. So I will say it is 114 crores. So now we can see the original offense was, original proceed of crime identified was only 12 crores. ED has enhanced the ambit of the investigation, and we have made it 114 crores. As per section 24 of PMLA 2002, the burden of proof is on accused to prove that it is not proceed of crime. Please just keep in mind this section 24. I will be discussing subsequently for this, because this has been, its constitutional validity has been challenged, and I will be coming back to. Just keep in mind, we will be discussing it in a detail subsequently. In PMLA, money laundering is an offense in itself, prescribing definition under section 3 and punishment under section 4. The predicate offense is a trigger only and does not set boundary for the PMLA investigation. There may be different set of accused in predicate offense and in the PMLA case. The crime may be done by somebody else, and the laundering may be done by somebody else. So it is not necessary that the persons who were accused in the crime can only be made accused in the PMLA, or the person who has been made accused in the PMLA are must be accused in the predicate offense also. These two are different, two sets of offense, two sets of trial, two sets of accused. So this is the one case study I have discussed. I will wait for this case study invites a lot of questions in my previous session so we will wait for that. Now I have just said that hardly 25 cases have been decided by the special PMLA court where convictions has taken place, or some acquittal has also taken place. So I thought it proper that I should discuss the first case in which conviction has been awarded. So this is the Narayanrai case, is the first case in which conviction has been awarded by the Ranchi Special Court in Ranchi. This is the first case in India in which conviction was awarded under PMLA in Jan 2017. Narayanrai was Minister of Town and Tourism Development in Jharkhand government during 2005 to 2009. He became MLA in the year 2005. He, along with other minister, Mr. Anosa Ekka, were accused in this case, but both were tried separately. Mr. Narayanrai has been convicted, whereas the trial of Mr. Ekka is going on. Predicate offense, the crime which they have committed was under section 406, 409, 420, 423, 424, 465 and 120B of IPC and section 11 and 13 of the PC Act. These sections are not very important. Few of these sections were has been listed in the schedule of the PMLA. They are scheduled offences. So the ED has taken up the matter and has conducted the investigation. So what was our base? You know, at the time of filing the nomination in the elections, the candidates has to file his financial property details along with the nomination. And what we found that Mr. Narayanrai has filed the following income or details about his property. That he was having cash of 10,000, bank deposit of 5,000, other NSC, etc. of 1,25,000. He was having agricultural land of 5.5 crores and jewelry worth 50,000 crores. And this was his property declared by him before the Election Commission in 2005 when he was filing his nomination for the MLA. And he claimed that his income was not taxable and no PAN was issued and hence no ITR was filed. So he said that I am not income tax payee, very meager income is there, and so I have not taken a PAN, I have not filed any ITR. Very good. So in 2005, that was our base, that this was his income in 2005. Now, when we started investigation, we found that he was proceed of crime after investigation over and above their known source of income. We have ignored his known source of income, whatever he was getting as MLA or as minister salary or allowances. In addition to that, he was having that much more than 3.72 crores, which were over and above of his known source of income. Much more than the disproportionate asset indicated by the predicate offense agency. The matter was investigated, the predicate offense was investigated by the State Vigilance Commission, and they have come out with some figures that their is still going on, their trial is still going on, but ED trial has been completed, judgment has been pronounced, he has been convicted, and we find that this much extra unexplained income has been found with him. And I have already said, Section 24 says that the burden of proof is on the accused, that from where this money has come, he could not explain. His wife and relatives were having no source of income, and it was held that Narayanrai has invested the money in immovable and movable properties in name of his wife and other relatives. Thus, he projected his tainted money as clean and legally earned money. He has kept a lot of money in name of his relatives, wife, who are doing nothing, no source of income. And the investigation proved that they were not having any source of income. It is all Narayanrai's money, which he is parking in the name of his relatives and wife. And the court was convinced with the arguments of the ED, and he was convicted for the offense of money laundering under Section 3 and was punished under Section 4 of the PMLA. He was convicted for rigorous imprisonment of 7 years. I have already said 7 years is the maximum punishment, but the judge was of the view that the public figures who was a minister, he should get an exemplary punishment, and so he has given him the maximum punishment of 7 years and also imposed a fine on 5 lakhs. And all the properties used in money laundering were also confiscated. All these property, 3.72 crores, which we have found over and above his known source of income, were also confiscated. So this is the Friends, this is the first case in which PMLA court has convicted somebody. The ED people were very happy. Actually, I will just go in the background. This PMLA has been, there is an international conference and on this. And this was the political declaration and global program of action adopted by the General Assembly of United Nations. And it was the international pressure that they were making on all the countries worldwide, that you should have a money laundering law in your country. Okay, very good. See, who can make a law for the country? It is your parliament or assembly only can make a law for your country. But they keep on monitoring that it is effective, how you are using it. So in this case, what has happened, we were finding it very difficult till 2017. Whenever we were going to the international conferences, conventions, or the foreigners were coming to us, they were asking, okay, very good, your law is good, you are good. How much conviction has taken place? And we have to cut a very high figure that no, till date, no conviction has taken place. So when this first case came, I was going to this Hague for a conference. My director briefed me that you must mention that the conviction has taken place in PMLA in India. And that is the importance of this case, because world was watching. Okay, you are having good law, you are having everything, good mechanism, but nobody has been convicted till date. And since Mr. Rai was a minister, was a public figure, he was not just a street person. So we were having a very good position in the international law. Now I will say one more case history we should go. That is the prosecution of Bhupender Singh Hooda, former Chief Minister, Haryana, and 21 other persons. This is regarding Panchkula industrial plot allotment case. Maybe through newspapers you may be heard about this, but we will go on the legal issues, not on the media. In December 15, State Vigilance Bureau has lodged an FIR against these people. But I think some was fired in the public interest PILs, etc. were filed that the State Vigilance Bureau may act partially. So the case was transferred to CBI. CBI case is still pending. No charge sheet has been filed yet. So this has become a very long drawn battle. I will discuss Section 24 also. I will discuss in this. But there is some problem with what is the ED investigation? Allegation was the allotment of 14 industrial plots to pre-selected acquaintances and denying allotment to worthy applicants. Allotments were altered 18 days after last date of application to favor few pre-selected applicants. Industrial plots were to be allotted, and there were people who were favored, pre-selected. Okay, you will be getting it. All the allotment procedure, option, whatever was done, that was a farce that was created. In fact, they were all coming after the last date of application, and all these industrial plots were illegally allotted to the persons who were known acquaintances, or some bribery has taken place. That is a subject matter of investigation. But of course, all these allotments were illegal. So that is the case. Major, the crime. The crime was that these industrial plots were allotted. What ED has done, all 14 industrial plots were attached by ED. We attached it under Section 5 of the PMLA, and it was attached in August 2019. Confirmed by adjudicating authority in Feb 2020. Now we were in a dilemma because we were attaching the properties and keeping it like that. There were a lot of hue and cry at the political level as well as at the judicial level, Supreme Court and all. They attach the property and forget it. And the person is deprived of the property, even if he is acquitted after some time. So there should be a time limit within which they have to file the prosecution. So there was amendment in the law in 2019 that after confirmation of the attachment by the adjudicating authority, within 365 days, the prosecution complaint is to be filed. So this a limitation was imposed on the enforcement directorate that you cannot have this attachments for time, unlimited time, indefinite time. You have to file the prosecution within 365 days. What was the dilemma? Dilemma was that the CBI has not filed the charge sheet. Whether the crime has taken place, not taken place, what has happened, how much he has done, that is yet to be crystallized. Investigation pending, no charge sheet has been filed yet in the CBI matter. Now, but if we don't file our prosecution complaint, it's the same thing. For ED, the CBI people call it charge sheet. In ED parlance, we call it prosecution complaint. It is one and same, the filing a complaint before the court. So we waited, and ultimately within 365 days, in Feb 2021 itself, prosecution complaint was to be filed. And actually by that time, no charge sheet was filed by the CBI. So this is one thing which has happened, which also we feel, but we are bound by the limitation imposed by the law, and it was filed. It was not only Bhupender Singh Huda's case, it has happened in so many cases, in fact, pan-India level. And a large number of petitions are pending before the apex court, where ED prosecution has been challenged on the ground that the predicate agency had either closed the case, or the accused has been acquitted, discharged, or the charge sheet is yet to be filed. See, I will just, because you are from this chartered accountant fraternity, you may not be much aware about the criminal law procedures. Criminal law, how it happens, first of all, it is FIR is filed. Once the FIR is filed, the investigation starts. After starting of the investigation, if the agency, say CBI or police, whoever it may be, may find that no offense has been committed, or this person has committed, this person has not committed, they may simply file a closure report, no offense has been committed. They may file a closure report, or they may file a complaint, charge sheet before the court. So at that stage itself, it is a charge sheet may be filed or closure report may be filed. And after trial, where the charge sheet has been filed, the accused either may be discharged, or may be acquitted, or may be convicted. So these all things, all possibilities and probabilities are there. Suppose the person is acquitted, person is discharged, what will happen to the ED matter? Charge sheet has not yet been filed. The predicate agency decides not to file a charge sheet. Then what will happen to the ED case who has attached a large number of property? So it's a very genuine question. When I have not committed the crime, in the crime I am being acquitted, in the crime I am being discharged, why you are taking away my property? In December 19, the apex court has stayed the trial of one such case. Actually, ED case, the trigger is only FIR. Once the FIR is filed, ED can start the investigation, ED can attach the properties. But after that, if these things happens, which acquittal or discharge or not filing of the charge sheet happens, so the situation changes. In Apex Court has stayed the trial in one such case in Chennai, where High Court has allowed the trial of ED case. In Apex Court has stayed the trial. What ED is telling that no, money laundering is an independent offense. Money laundering is an independent offense defined in Section 3 of the PMLA, punishable under Section 4 of the PMLA. If the ingredients are there of Section 3 are fulfilled, the accused should be convicted under PMLA. The FIR is only a trigger. Once the FIR is filed, we will start investigation. This is no linkage. What happens to the predicate offense is having no linkage, and we can investigate and we can try him independently. In fact, what has happened in Section 2019, after this, there is a amendment in the Act that ED prosecution is not dependent on the trial of predicate offense, and this amendment has also been challenged in this Huda case. The 3-judge bench of Apex Court had stayed the proceedings in ED Special Court. The matter is pending. A large number of cases have been tagged with this case. I understand that I have just today seen that there is a more than 150 cases tagged to this case in Supreme Court. This is the thing where I was referring earlier. In the Supreme Court, continuous 3 days hearing has taken place on year 9th and today is 10th, 3 and in this matter, since as I have said, more than 150 cases are there, so court has asked some few senior lawyers that you will only address the till now. Mr. Siddharth Luthra has completed his argument. Mr. Kapil Sibbal has completed his argument. Mr. Abhishek Manu Singhvi has completed argument, and now Amit Desai's argument is going on. So all these arguments are going on. In fact, Abhishek Manu, yesterday I have read his arguments, what was going on in the court. Abhishek Manu Singhvi was very particular about the constitutional validity of Section 24 of the PMLA, which reverses the burden of proof that it is the accused. Once I say it is the ED says that it is proceed of crime, the burden of proof lies with the accused. No, it is my legally earned money. Mr. Abhishek Manu Singhvi was arguing in Supreme Court that this power has been given has reverses the burden of proof without safeguard, and it gives unchecked power to ED to take over the properties. I am sure whenever, because it is all going on since last 1.5 years, whenever the judgment comes, it will be very landmark judgment, and it will set boundaries for the functioning of the ED. We are eagerly waiting for the outcome of this. The 3-judge bench is hearing this matter. Few more recent development has taken place. I will say that this is a new law. It is being it is the formation stage. Properties are being attached, people are being arrested, all these things are happening. And in fact, as I have said, the main prosecution case has not been tested by the Apex Court. So no legally enforced precedent is there. But for these peripheral things, so some matters has gone to the Apex Court, and some pronouncement and some clarity has come, like civil matters regarding attachment of proceed of crime. Which property can be attached? This is a case. The attachment of proceed of crime has been challenged in several matters, and the Apex Court has also occasion to deliberate on this issue. So these peripheral issues has gone up to the Apex Court.
The basic issue is what is proceed of crime? Which property can be attached? And the third, right of innocent claimant in the property. The property, house is mine, bank has mortgaged the property. Bank is an innocent claimant, having a charge on the property. He has not committed any crime. He is not involved in money laundering. So how to protect the interest of the innocent claimants? These three issues I will discuss now. What is proceed of crime? Proceed of crime has been defined in section 21U. What does it say? Proceed of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. So it is property derived or obtained directly or indirectly by any person as a result of criminal activity relating to the scheduled offense. So criminal activity should be relating to the scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. One explanation has been added in the Finance Bill 19. For removal of doubts, it is hereby clarified that proceed of crime, including property not only derived or obtained from the scheduled offense, but also from any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. This is a very, what does it mean and how it will be, where it will be applied? It is all being tested by the Supreme Court. First of all, let us conclude this proceed of crime means. What is the proceed of crime? Is that this is the definition as per this. Three things have been, I have cut it into three here. Then, now what is the first is that any property derived or obtained directly or indirectly by any person. So, when the criminal activity will take place, definitely criminal activity will take place first, and then only he will derive some property or some money out of it. So, any property which is acquired prior to the criminal activity, can it be said that it is a proceed of crime? Reading by the first, no, it cannot be said, because as it should the property should be as a result of criminal activity. So first the criminal activity should be there, then there should be a generation of proceed of crime and then laundering. But the confusion was the value of any such property. So what ED was doing, any property, even their ancestral property was being attached. Okay, we are attaching it as a value of such property. You have earned a lot, and there is a proof that you have earned proceed of crimes, but we are unable to trace where it is there, where it is. So I am attaching this property as a value of such property, which was even acquired prior to the criminal activity. So this was being done, and this was only challenged in this case I am going to discuss, in Seema Garg case. And in second thing is, first let me complete this one. This is the Seema Garg and Deputy Director ED case. It is a matter of Punjab and Haryana High Court has decided it. The property was purchased in 1991 and 2012 by legitimate means. There is no allegation that these were purchased out of the proceed of crime. There is no allegation. Actually, the offense, scheduled offense, has taken place in 2013. What was the offense? It was a fraudulent refund of VAT in 2013. The property was attached in year 2017. So let us see the sequence. Property was acquired in 1990 and 2012 by legitimate means. The offense has taken place in 2013, and in 2017 we are attaching this property which was acquired in 1991 and 2012. In this case, dispute was whether the property acquired prior to commission of the scheduled offense can be attached. And there was a side issue also, the relevance of recording region of belief under PMLA for attachment of the property. That was a side issue. Definitely, the law provides that there should be a region of belief should be recorded that why we are attaching that is. But this attachment was confirmed by adjudicating authority and the tribunal. The Punjab and Haryana High Court held that out of the three limbs of definition of proceed of crime, there are three limbs. We have seen these three limbs. Any property, value of such property, or where such property is taken or held outside the country. What they have said, out of the three limbs in the definition of proceed of crime, the property acquired prior to the scheduled offence, that is criminal activity or introduction of PMLA, cannot be attached unless property obtained or acquired from scheduled offence is held or taken outside the country. Thus, for the POC falling under the third limb, the property acquired prior to the scheduled offence can be attached. So, I'm coming back once again. So, there are two types of. One is that any property acquired as a result of criminal activity or value thereof, or this which has been held outside. So, what Punjab and Haryana High Court has held, that for the first part, you cannot attach a property which has been acquired prior to commission of offence. But in the third limb, where such property is taken or held outside the country, then the property equivalent in value, there is no restriction. In this case, you can acquire the property even which has, you can attach the property even which has been acquired prior to the commission of the scheduled offence. So this was clarified that if the property is held outside the country, you can attach a property which has been acquired prior to the criminal activity. In all other cases, you cannot. So you have first to prove that no, this property has already been taken out from the country. So I am acquiring it as a value of such property. So what are the director? That recording of region, the director or any other officer is bound to record regions which may be specific and more mere reproduction of words. So that is the region has to be recorded. That is not a bigger issue. I'm on the bigger issue, that is which property can be attached. So in case it has been taken out of the country, any property, even property acquired before the commission of the offence can be attached. In all other cases, only property acquired out of the after the criminal activity can be attached. Then what is the region? What is the value thereof? Value thereof in first case means that suppose you have looted a bank. That from that money you have purchased a house. You have sold that house and purchased a land. So what is that? What was the proceed of crime? Was the money looted from the bank. But you go below and you can attach the land as a value thereof. So if the proceed of crime has changed its shape, changed its nature, then even that can also be attached. That is what is authorized. Not that an ancestral thing you are going to attach. So this was how it was interpreted by the court, and in my view, it is the correct interpretation. And in fact, what has happened, the ED has filed a special petition, SLP, before the Supreme Court, and it has been dismissed. So as on date, this is the law of the land, and this is the correct interpretation of the POC, which can be attached. In one more case, the Supreme Court in Kumar Pappu Singh versus Union of India, others, here what has happened, IDBI has lodged a complaint before CBI that between 2009 and 2012, bank has sanctioned Kisan credit loans to 101 borrowers to the tune of 74.99 crores. The loan were disbursed to the individual account, but subsequently transferred to the aggregator's account and later misappropriated. This Kumar Pappu Singh was aggregator. He made a society type of thing, or he just mustered few hundred people that we will be having some fisheries or something like that. And then in those people's name, Kisan credit card were made and the loans were issued. But all those loans, although initially it has gone to the account of that person, but 101 borrowers, but all these money came back, routed back to the Kumar Pappu Singh's account, and it was misappropriated. The loan remains unpaid, and Mr. Kumar Pappu Singh invested the said money in fisheries business and suffered huge losses, and he could not repay. The people remained, and then this matter came to the CBI, IDBI. This bank lost the FIR before the CBI. Investigation continued. Now what has happened? The properties of Mr. Kumar Pappu Singh were attached. What property was attached? Directly connected to the proceed of crime, and some properties acquired prior to the commission of scheduled offence were attached as deemed tempted property for the purpose of attachment, showing that these are the value thereof. Adjudicating authority and tribunal both has confirmed the attachment. Here again, before the High Court, the point before the High Court was whether the properties acquired prior to the commission of scheduled offence can be attached under limb 2, value thereof, the definition of the proceed of crime. The Honorable High Court, relying on the judgment of Punjab and Haryana High Court in Seema Garg's case, and also distinguishing between the second and third limb of the definition of POC, held that properties purchased before the commission of the offence cannot fall within the definition of POC under the second limb and cannot be attached or confiscated under PMLA. However, it was observed that any property can be attached under third limb. So as I have said, that property which has been taken out of India, for in lieu of that, any property can be attached. But if there is no proof, no evidence that the property has been taken out of India, properties only which has been acquired after the scheduled offence can be attached. This is the position of law at present. Okay, next I will see. I have just said that there was what will happen to the claimant with a legitimate interest in the attached property. Mostly, it is observed that there were innocent entities having legitimate interest in the attached properties and have been victim of crime, like banks, like in bank fraud cases, investor in cheat fund cases, the victim in cheating cases, etc. To protect this their interest, Section 8.8 was inserted in the year 2015. 8.8, where a property stands confiscated to the central government under subsection 5, the special court in such manner as may be prescribed may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss or as a result of offence of money laundering. So, now, and I will just read through first, then I will explain it. This is a very interesting story behind it. Provided that the special court shall not consider such claim unless it is satisfied that claimant has acted in good faith and has suffered the loss despite having taken all reasonable precautions and is not involved in the offence of money laundering. Now I will tell you the background. As a joint director ED in Kolkata, I was investigating Sarda chit fund case and Rose Valley chit fund case and some other like this. And matter were being monitored by the Calcutta High Court also. Initially, thousands of investors were gheraving the High Court daily. And the court was just, they were entering into the court as if the court will give them money. So, one day, the Chief Justice, Ms. Manjula Chiller, she was here. She called me and told me that how these people, the poor people, can be helped out because they have been victimized, they are suffering. So I told Your Lordship, we can't do anything. We have attached it. Now it is up to the court. It is everything in the court. we can only attach. We don't have any provision in the PMLA that we can give it to anybody else. It will be confiscated to the government. Then she was very reasonable. She said that but they should get the money. I took up the matter with the higher ups that no, there should be some provision that to protect the interest of the legitimate sufferers. And as a result, this has come. This amendment to the law has come at that point of time. Okay, once it is confiscated, then the court may distribute it to the person's claimant with a legitimate interest, provided they have acted in good faith, their hands are clean, and they have suffered in spite of taking all reasonable precautions. We were very happy that okay, we have amended the law, now they can claim. But unfortunately, what has happened? The trial takes long run. The claimant has to wait completion of the trial, which was a long run process, and in fact was not of much use to the claimant, because the trial will not end. Even if the trial ends, somebody will go to the High Court, somebody will go to the Supreme Court. The person will not get the money in his lifetime. Once again, the Chief Justice was of the view, no, it is not done. It is not done. You people have not, this law has not been, and this is the, okay. We again took up the matter with the Ministry of Law. No, it is not serving the purpose for which it was made. And actually, people in my organization and other, they appreciated the concern of the court. And then what has happened? A new proviso was added, provided that the special court may, if it thinks fit, consider the claim of claimant for the purpose of restoration of such properties during the trial of the case in such manner as may be prescribed. So now, even during trial, the money property can be restored to the innocent person. This law was amended. And for this, a rule was framed. The Prevention of Money Laundering Restoration Property Rules was framed. And from this, a new clause 3A was inserted in these rules, prescribing the manner of restoring property during trial. Recently, now, actually, I will tell you one story, one case where it has been done. In the case of Kingfisher Airlines, Vijaya Malia case, everybody knows worldwide, everybody in India knows Vijaya Malia case. And the lending banks have been benefited from this provision. The lending banks were innocent victims. Their money was blocked. He has not paid the loan taken by him, ran away. So they were this is a recent judgment order in 1st June of 2021 by the Court of Special Judge of CBI in Greater Bombay. See, who can give this? Who can do the restoration? The court who is trying the offence, which the court is trying is the special judge of the nominated, designated judge for the ED. So he has passed the order in PMLA special case in the matter of Deputy Director, Directorate of Enforcement and others versus Kingfisher Airlines and others. Who was the applicant? Innocent. So bank made an application before the court. ED has given no objection for the same. Actually, we have only introduced this provision. We were very happy that the provision which we have introduced is being utilized by some legitimate claimant. The special court restored the properties attached by ED to the applicant banks in the order referred in the previous slide and one similar matter. So this 6203 crores, which was due to the bank, has been restored by the court to them. It's a big thing from the person who has fled the country, and from his property, the bank's claims has already been entire claim has been recovered. It's a great achievement. But the bank has to give be given such claimant to produce such restored property before the court if so required. So this is one thing, new. As I have said, the law is farming. So this is one thing. two, three things. One, that which property can be attached, one that has been crystallized. This is that how to protect the interest of the innocent claimants, that has now been crystallized. One more thing has happened. One more, I will say, that is the Insolvency and Bankruptcy Code, IBC. See what is happening. Suppose what is happening, that bank is defrauded. The NPA, the account becomes NPA. Then they lodge a FIR. The banks are filing FIR in CBI for bank fraud cases. The PMLA is a new law and evolving. Similar is the position with the IBC. IBC is also a new law. Insolvency and Bankruptcy Code is also a new law. What is happening? Banks are filing FIR in CBI for bank fraud cases. Since the offences fall under the category of scheduled offence, ED also start investigation under PMLA. After investigation, the ED used to attach the property, Simultaneously, banks are also initiating action under IBC before the NCLT. Both the acts has got non-obstant clause, empowering them to override other law. Non-obstant clause is that in spite of if any other law says it will not. So both the law has got non-obstant clause. But there is a Supreme Court judgments, so many judgments. If there is two law, both having non-obstant clause, the latter law will prevail. So IBC is a subsequent law and it is a latter law. So it was claimed that IBC will prevail over PMLA. That is what the issue before the Supreme Court. Manish Kumar and Union of India and others. This was the acquisition of Bhushan Power and Steel and SR Steel case. My friends, you must have heard, right now this IBC has actually disposed of a large number of properties. Earlier, what was happening? Bank was sealing the property. It was being just rusted, and then it was nobody's property. Now what is happening? The company itself is being sold. Like Bhushan Power and Steel has been sold, SR Steel has been sold. So many these properties have been sold to the new owner. After auction and other things, here it was in some Tata has taken some, I think JSPL has taken over property. So in the process of from the forum of NCLT, the properties has been disposed of. But already ED case is going on. ED has attached some of the properties out of that. So it is a very peculiar situation. NCLT selling the properties, auctioning the properties, which has already been attached by ED under the provisions of law. It is not illegal attachment. The attachment is there and it has been attached. So, now IBC imposes moratorium monetization and restrict its asset alienation. PMLA empowers to attach, confiscate and dispose assets involved in the money laundering. And not only this, the company is already accused in some PED cases also. So it was a very peculiar situation. What will happen? They have purchased the Bhushan Power and Steel, and that property has been attached by ED. Where this person, this was purchased by Tata itself. Where they will go? So the matter went up to the Apex Court, Supreme Court, and after a lot of deliberations, Supreme Court held that the IBC will prevail over the PMLA. Here, I will say this is the correct position of law, because if that is not allowed, nobody will purchase. You never know what will happen to this property. This Bhushan Power and Steel was acquired by Tata by more than 40,000 crores. They have paid this much money. The banks have already been repaid. The employees were retained. The employees are working there. Otherwise, what will the company will be locked, all the employees will become jobless. Nobody will be getting anything out of it. Here, the company, the shareholders, everybody is happy. And that was the purpose of this IBC and the parliament with all its wisdom has passed this law. Now, if the ED, this PMLA powers are being used against these properties, no purpose will be served. But it will defeat the entire purpose of the IBC Act. So the Supreme Court was of the view, no, in such situations, all these properties, the attachments will be removed. The property will go to the genuine buyer who has purchased it. Yes, but the people who were earlier, who has money laundered, who has cheated the banks, they will be tried. Their trial will take place. Only the civil component of this, that is the attachment. In fact, if there is any other property that can be attached, but this property which has been dealt by this NCLT and has been sold, handed over to the genuine buyer, that cannot be touched. So this is a very recent judgment in 2020. Only this year, last year only it was reported. So this is the one more judgment I would like to say. And I have been told that there are a lot of questions waiting for me. So I have just slightly roughed the slide, and thereafter all the...
You can take your own time. Please go through all the slides.
Huh?
Please go through all the slides. Anything you have, please feel free. We can take the questions later.
Okay. So nice of you. Thank you very much. I thought I have promised that 1.5 hours I will close, so
but finish your slides. It's very interesting. Lots of practical issues, and many questions are getting answered through your slides only.
Okay, so first of all, I will like to this Bhupinder Singh Huda's matter. In fact, I think it is the biggest matter going on in Supreme Court. And I was pursuing this, what was happening on yesterday, day before yesterday, and today I could not follow. Today it was, and I will say all the legal luminaries of the Indian everybody except Harish Salve, everybody was there. And I'm just Mr. Abhishek Manu Singhvi is a very senior counsel, and then the matter is before Justice A.M. Khanvilikar, Dinesh Maheshwari, and C.T. Ravi Kumar, is a 3-judges bench, and then this Mr. Abhishek Manu Singhvi of the view, there are so many draconian laws in India, but this type of burden of proof shifting to the accused person is not there in any law. You people are chartered accountants, very well versed with the income tax matters. So why this has happened, how this has creeped in this PMLA, I said it is a blend of civil and criminal law, number one. For procedural part, for criminal part, we have taken the procedures from CRPC, and for civil part, we have taken the procedures from search, seizure, recording of statements, all those things. We have taken the procedures from the Income Tax Act and Income Tax rules. Now, you know, what is happening is in income tax, if something is found in your premises during search, you have to explain it. It will be presumed it is yours and you have to explain its source of income. It is already there in income tax. But income tax being a civil law, only penalties, etc., fine and taxes are being imposed. Nobody has earlier objected it. Objected, but this is still there. What it has been shifted to a criminal law. Now it has been shifted in the PMLA that whatever you are owning, whatever you are having, you have to prove that it is a genuinely legally earned money, legally earned property, legally earned money. So in fact, it has been transported from Income Tax Act to the PMLA. But these people are saying, this is a criminal law. Here evidences are very serious in nature. You cannot just you just frame a charge and then you convert it as if in the disproportionate, like in Prevention of Corruption Act, there is a provision of disproportionate assets for government public servants. So you have to prove, like the Narayanrai case, the Prevention of Corruption Act has been invoked. So it is a law as if it is a Prevention of Corruption Act, and everybody, all public at large has been brought in the ambit of the Prevention of Corruption Act. Whatever you are owning, you will have to justify it. In fact, this slightly what is happening is that there is a distinction between civil and criminal law is diminishing. After this PMLA and so many things, SFIO and all those laws now which is being brought and interpreted, these civil and criminal law is being, the difference between these two are being distinguished, with this diminishing, which may not be a correct thing. From all that civil law, tax evasions, etc., were taken at different pedestal, not as a criminal law. But now somehow or other, if somebody falls in the wrong in an income tax matter, there is a FIR, and then there is a ED matter, and all those things start. Recently, what I have seen, the Customs 135 is in the PMLA, is a single offence under PMLA. Evasion of income tax and evasion of central excise or evasion of GST is not. It is not there. I have seen in 2-3 cases in the West Bengal government, the GST, state GST department has, whenever you evade some tax, you evade GST, how you will evade? You will fabricate some document, fabricate some records, fabricate some data. Then only you can evade. This fabrication, if stretched, falls within the purview of the Section 420 of the IPC. The state GST has lodged FIR with the police under 420. And then once the FIR under 420 and 120B is lodged, ED gets a foothold. ED lodges their FIR under PMLA. When the evasion of GST has not been made a schedule offence under PMLA, by circumventing the provisions and you are making it a provision, offence under PMLA, this should be avoided. This is avoidable, I will say. Because in its wisdom, the parliament, the legislature has not made evasion of GST a schedule offence. By this circumventing way, we are making it a schedule of offence. Whenever there is a evasion, either income tax evasion, customs evasion, GST evasion, some fabrication of documents will always be there. I am over invoicing, I am under invoicing, I am not paying my GST, I am so they will be there. From in the thin air, nobody can evade the taxes. So these things are happening, and actually this diminishing this difference between the civil law and criminal law, it is not a welcome thing. I think now I will like to close the issue, and I will be taking up the question answers.
Wonderful insights, sir. Excellent, Mr. Chand. A few questions have come from participants. We may identify unusual deposits and withdrawals, but how do you decide whether the amounts withdrawn are for money laundering?
Section 24. It says that the burden of proof lies on you. You said, you tell me from where the money has come. He could not explain. I think we are referring to the cattle smuggling case. Hello?
Yes.
So he was doing smuggling, cattle smuggling, all those things, and there was a cash deposits over 100 crores in his account. He could not explain.
Fine, great. Another is reasons why cases take so long. In such cases, is it lack of support from the government, or there are staffing issues in the ED? As in one case, CBI charge sheet is also pending to be filed. What's your take on this?
See, definitely it was taking time in filing prosecution complaint before the ED, by the ED. But now statutory limitations have been, because if we attach some property within 1 year, we have to file the prosecution complaint before the court. Now it is in the ball is in the with the court. So far as ED is concerned, we have tried to make provisions for this. Okay, how we will tackle it. But so the judicial things are there. It is there. Judicial, millions of cases are pending in judiciary, and that is the procedure is also, the trial takes place. That is there. That is our lacuna in our judicial system. Investigation is not taking that much. We are being monitored. We are being you do it fast. You do it fast. But suppose sometimes what happens? Suppose somebody runs away out of India. Now the case we have to record his statement. The case becomes difficult to file a charge sheet. CBI may be facing that kind of problem. And one more thing I will say: ED is not dealing with small people. These people are very big, very influential. Even a drop of hat, they will go to High Court and Supreme Court. So we keep on running from this court to that court. I will tell you, in Rose Valley case, within 6 months, 45 writ petitions were filed in various high courts. There was one IO and one assistant, because it is IO investigating IO system. If you want to file a prosecution complaint, you have to be one. There should be one IO. The IO was running from Patna to Bhubaneswar to Calcutta to Delhi, and for 6 months, 9 months, he could not get any time for any investigation. So these things are also there. Now what has happened? We have attached everything. Now he is cool. Now he is not filing any writ petition.
Fine. Now, very, very important question, which is there in many people's mind. Do you see many cases of interference from who are called influencers, and how do you handle it? Any examples you can cite?
First of all, there is a lot of myth that it is we are being influenced or politically used by the government here and there. Because see, we are public servants. Tomorrow which government will come, which government will not come. We will have to save our skin also. What is happening actually, I am telling you. Suppose I am having 100 cases. Okay. One case is regarding a person who is political adversary to the present dispensation. Maybe. They will start asking what is happening in that case, what is going on, what you are doing. In such things, that case takes slightly priority. That is this is what happens.
Good. What if the proceeds of crimes have been used for lavish expenses and or losses, but no assets are found for attachment. How do you handle such cases? Do you come across many such cases?
Yeah, we have come across many cases. Not only with lavish expenses, it has happened that you are running a business and you have suffered a genuine loss, and your account has become NPA, and all those things have happened. It's there. But if that was what was happening, people ED was attaching the ancestral property, also property acquired and earned much before the crime. So now the things are there. No, if you can, you have to make a linkage with the criminal money, then only you can attach. There should be a linkage with the criminal money. If it's not there, nothing. He has spent the money in lavish expenses or whatever is there. You charge him for money laundering. There is no property, or very little property.
Right. What if the proceeds of crime are transferred to a charitable trust, which is a separate entity? Do you come across such cases?
Yeah, we have come across such cases. And in fact, if it is a genuine charitable trust, I will tell you, this was the Bharat Sevak Samaj. It is like Ramakrishna Mission. Bharat Sevak Samaj is also a very respected, very reputed trust. Some people might have heard about its name. They have returned the money. It was 1 or 2 crores this Rose Valley people have given them. They have returned the money. We'll ask them to proceed of crime. Please return. Otherwise, we will attach something. They don't want any bad name.
That's wonderful.
They have returned the money.
Good. Most of the professionals, chartered accountants, auditors, come across many cases of transaction with related parties by promoters of companies. Can those come under PMLA, and how? Are there any instances of such cases?
No, I am telling you. Once again, I will say that first of all,
particularly for listed companies, if you can share any examples.
No, I am telling you, first of all, there should be a crime. And which crime? The crime should be listed in the schedule of the Prevention of Money Laundering Act. So whatever you are talking about, is it a crime under any law? It is not a criminal law. It comes subsequently. First of all, it should be a crime under any criminal law. Whatever you are referring, is it a crime in any other law?
If it not prima facie, but there can be beyond. It depends on the intention of the promoter.
If it is I will tell you, it is in SEBI also, there are some cases, 1 or 2 provisions are there which are in the schedule offence. But the person can go through the list of given in the appended to the PMLA, and I will just tell you. Offences under SEBI, Security and Exchange Board. It is 12A, read with section 24. Prohibition of manipulative and deceptive devices, insider trading and substantial. And 24 is acquisition of securities or control. These 2 sections are under schedule offence. If anybody is committing this, so he can be tried by SEBI for these 2 offences, and this will be a schedule offence. ED things can also be, ED case can also be registered against him. In fact, for 24, we have in Rose Valley case, we have filed a charge sheet also for violation of this SEBI case.
Right. What is the update on the Vijaya Malia and Nirav Modi case? Both of them are associated with the corridors of UK.
One by one?
Yes.
First of all, Vijaya Malia is concerned. I will really feel pity. His dues was around 6,000 crores. And then adding the interest, it is around 9,000 crores. I know property worth more than 20,000 crore has been attached. Right now, I have just shown that example also in my case study, that bank has got its entire money back. I have shown yeah. So now the only question is that money has already been retrieved. The issue is that if he comes, he will be arrested. He will be arrested, and then what will happen? He will have to face the trial of under PMLA. That's why he is running out. Now it is not a issue regarding money.
So now it is all about conviction.
Yeah, the bank paid for recovery of 6203 crores before DRT, and this entire thing has already been, they have already got the money.
Right. There is a question here. Is the maximum conviction only 7 years in PMLA? In other offences, sometimes it is more, but PMLA is only 7 years.
Only 7 years, yes. And if it is a case, the predicate offence is related to narcotics, it is 10 years.
Okay. Is there any overlapping of the various laws related to frauds, crime, etc.? What is the experience in that? Any complications?
Complications sometimes come. There is as I have told, the law is forming, like the complication has come in with the IBC, banking law and the ED. That has been resolved by Supreme Court. There is a distinction. One is crime, one is PMLA. Criminal law is being investigated by police, by CBI, or by customs, by Narcotics Control Bureau. All these agencies are there who investigate the crime. The ED or PMLA is for the proceed of crime. Whatever you have earned out of that may be attached. In this case, I will tell you. Cattle smuggling case. What has happened? The gold was seized by DRI. When we made that also is a proceed of crime. We have also attached along with his other properties. Now DRI, the case was adjudicated by the custom authorities, and they have confiscated the gold. Now the gold was confiscated by DRI and it was attached by ED also. But before the court, we gave no objection to that. Let it be. Ultimately, it has go to the coffers of the government. Once it has been confiscated, my case will come. I don't know when. In one case, it is already being confiscated. We gave no objection. That let it be confiscated by this.
Right. Recent directive to recover the monies offered by the offenders by dropping the criminal prosecutions, if any, against the offenders. What is your view on the subject?
It is already I think the court just about a week back, the Supreme Court has also made some observation like this. If somebody is willing to pay the money, why you are after him? But the problem is that the question is that the crime has been, there is one thing is the bank, the money of the bank, it will go to the bank. But if what will happen to the crime, what you have done? It is just like people keep on arguing that suppose you have stolen something, you are caught, you have repaid it, you have returned it. That it takes away the offense of theft. But like Vijaya Malia matter, I am telling you, I was sometimes associated with it. I will tell you that he has not from this account to that account, that account to that account to pay his bank dues, to keep his record straight. He might have done. But I will tell you that during that period, his company has suffered more than 15,000 crores loss. All airlines were suffering. Air India has suffered more than 45,000 crores. But that was also public money. Air India, what loss has been suffered by Air India, that was also public money. But Vijaya Malia has not taken out or siphoned off the money. But these things have happened, and then, media and position and all this become issue, he wants to, okay, you try me, but you don't arrest me right now. If I am proved guilty, you send me in jail. But nobody is listening.
Right. Which are the offenses of money laundering, and how they are different from scheduled offenses?
That is the scheduled offenses. Suppose you have committed a dacoity. So dacoity is the scheduled offense. You have entered somebody's premises, you have beaten him, and you have taken the money. That is the scheduled offense. After that, role of ED starts. What you have done with the money? You have gone and deposited it in the bank. You have purchased a land. So now you are laundering it. That was your criminal money. You are laundering it to look it and projecting as if it is a legally earned money. So that is the role of ED starts.
Right. Now, a very practical question. There are many professionals, chartered accountants involved with the banking industry, huge number. And banks have a lot of NPAs and their full focus is on recovery. Now, there are so many laws and options available, which according to you, based on your experiences, are the best options available to bankers to which are lending money to promoters or corporates, and which is the best way for fastest recovery for getting the money back? You can highlight some experiences and also your suggestions based on your experiences.
See, unfortunately, what has happened, there is the government and RBI has made it a mandatory for the banks. If there is a fraud, account is declared as a fraud, and after more than certain amount, 50 lakhs or some 50 crores or something, FIR has to be lodged. That is mandatory now. So once FIR is there, the CBI comes into picture, ED comes into picture, banks, first of all, they start scrutinizing bank officers' roles. Sometimes they are guilty also. I'm not saying that every time they are genuine. But then things become goes out of hand from the bank. Sometimes we have seen they have done OTS at a very small amount, 30%, 25%, 20%. That also is being looked at suspicious. That also looks suspicious. This another thing has started. This what is called RP. This is who purchased the loan from the banks. That is they take and then they step in the shoes of the bank and they recover the money. In this case, what exactly is that? This is a very effective. This IBC and NCLT is a very effective way. Like the judicial system in India is really time-taking process, I will say. Wherever you go, it is time-taking. The best way is that you negotiate with the person if he is in a position to pay, and that is the best way. OTS is the best way.
Right, one-time settlement. It saves a lot of time and trouble, and also gets money fast. You are a very bold person handling so many sensitive cases, dealing with so many criminals and also big sharks. How do you find that experience, the journey, excitement, safety, danger? Can you share your emotions about this journey?
So nice of you asking this personal question instead of these all technical questions. It was really very enriching. And see, what I feel, this judiciary comes later on. We come first. Suppose some innocent person, I charge him for some case and he is found innocent after 10 years, but he has suffered 10 years. From my own pen, I have given sentence for 10 years, which is not very clear. He has suffered 10 years because of me, because of my wrong decision. So that is, we have to be very particular and judicious during investigation also. It is not that we should throw everything in the court and let the court decide. The decision of the court comes after a long time. The person suffers a lot by that time. And one or two real actual cases I will tell you what has happened. A person he was being investigated by CBI as well as by ED. He was an old person suffering from cancer His son was he was IIM graduate. So but because of this, every day he was coming with his bag along with him and sitting there and going here and there. He did not take the placement offer in the IIM. And I was observing him, he was deteriorating. I just told him, you will not come tomorrow. From tomorrow, you will not come to this office. You go, you do your work, whatever you are doing. Let him suffer. He has done, let him suffer. We will be considerate to him. Nothing will happen to him in our office. But don't spoil your life. This matter is not going to end in a day or two or in a month or in a year or a few years. It will continue. They actually heard me, and then within 1 year, what I found, the person has married his daughter who was not getting married. This boy is working somewhere, getting good amount of money. His case is also going on. That is there. But even without joining him, the case is going on in its own way. So I'm happy that I have saved the career of that boy. So even if something has happened, we'll have to see that entire family, everybody should not spoil everything.
Excellent. One interesting question has come. Some of the banks and financial institutions are treating senior professionals as guilty for reckless lending, careless lending, and are such professionals scapegoats? Or you find there are genuine cases, many genuine cases, and they are guilty and must be punished?
It is both. There are bankers, I have found bankers who has taken money for granting loan. We have got clear-cut evidences. आपको बताऊं, आना पाई जोड़ के 10% उनके अकाउंट में ट्रांसफर हुआ है. Can you believe? Exact, मतलब the last digit of even this has not been rounded off. It has been transferred in the account of the bank. Yeah. How you can say it is not like that? It is not one in 2-3 cases. Exact 10%. So it is not like that. They see what we have observed, 2 things have happened. One is that reckless lending with some consideration, like this the case I am telling you. Second is that your account is going to become NPA. If the account becomes NPA, bank is also in trouble. It is only not the borrower is in trouble, the bank is also in trouble. So they try to save it or to postpone the declaration of NPA. Sometimes in between the company survives. In that case, they will give you loan in some other account, some LC account here and there. Then they will see that you pay your this EMI they keep on continuing for few months. Sometimes company survives, revives, and things settled. Sometimes, in one case, I know the person has raised his no, sir. Every month, my loan is increasing by 25 lakhs. I cannot now bear anything more. So these things happen. One case I will tell you, this is really which has pained me. It was a nationalized bank. The bank chief manager was hand in gloves with the person. The second man was also somehow involved. A young girl, as a provisionary officer, she joined the bank, hardly 6 months, 8 months working there. And some loan was to be sanctioned, and there were 3 signatures were required. These 2 people, who were the real culprits, they signed and asked that girl also to sign it, because it is 3 persons required. In good faith, because he was his boss, chief manager, role model, she also signed. It came out fake, and the CBI filed a charge sheet, and she was also made an accused. Unmarried girl, hardly 26, 27 years old, she was made an accused. My officer also summoned her. She came. She could not control herself, I am telling you. Sir, what will do? She was just monologue type of things was happening. Sir, what will happen to me? Will I go to jail? I'm just telling you the words. Will I go to jail? If I will go to jail, my mother will die. She loves me a lot. And if I go to jail, she will commit suicide. Then after some time, she is telling, sir, anybody will marry me if I go to jail. These monologues, she was, sir, you will arrest me. I said, no, I will not arrest you. I just took my phone and asked the SP CBI, why you have made her accused? What she has done? He told me, sir, no, actually, we also feel very sorry. But if we have left her, the other 2 persons who were the real guilty, they would have asked for equal treatment, and they would have also been spared. So that's why we will have to make her also an accused. We are really feeling sorry. You have done a sin. I told him that you have done a sin making her accused. And then, anyway, we have not made any accuse. We have not done anything against her. Next, I did not call her, but that pains me. Still, I remember the words, the way she was talking to me. Sorry, I had just become.
Thank you very much. This is excellent. One last word from you. You have got so much talent and experience, courage and integrity above all. In this role, integrity is very, very of paramount importance, right? And that is why, in fact, the Prime Minister also considered you and gave you the Meritorious Award. A message from you regarding your experiences with chartered accountants, their involvement with PMLA, money laundering, whichever way you can share, and also your words of wisdom for the chartered accountants across the country and across the world. That will be a wonderful insight from you. Thousands of chartered accountants are serving millions of entities, corporate, non-corporate, and can play a meaningful role. Your words of insights, experiences, in both ways, positive, negative, and the message you would like to give to all chartered accountants. This has been one of the most interactive webinars with excellent case studies.
Yeah, Mr. Manoj, you just asked me earlier that about the political and other pressures being put on the officers of ED and other agencies by political dispensation or other things. Am I correct?
Right.
I will say that kind of pressure is coming on the chartered accountants also. They are engaged by a very big industrial house, business house, and they ask you to give a certificate like this. 90% people will give, in spite of knowing that this is not correct. That is where the problem lies. You will have to learn to say no what is wrong. See, government has given you, reposed faith in you. You are chartered accountants, your certificates are being honored, actually I am originally from customs. So chartered accountant certificates, etc. We take it as a blindly, we accept it. And if you don't do, you are a public servant in that way. If you are not doing your work properly, you are not discharging your duties properly, I will say that is unfair. So my message, rather I will say to you people, is that you should consider as an impartial, independent person, recognized and certified by the government. You are not employee of your client. If you think that it is, I have seen people who has refused, and in fact, he has refused, one more person has refused, and third person has signed it. And we came to know that when we asked them why you have refused, Bola sir, it was slightly, I was not busy, then I could not, but somebody has obliged him. So that is the thing, you should think that you are doing a public service. You have been authorized for this. Just by somebody is telling you do this, you should not, and you cannot, and you should not. That is what I feel, that this message should go. No, you are an independent person. You are not employee of your client. I think that's all. That is the
excellent pearls of wisdom, words of inspiration for all chartered accountants across the world, including those who have qualified today's results. So many more students would be encouraged to join with chartered accountants, becoming top man of character and servicing the stakeholders and becoming partners in nation building. Really wonderful presentation, deep dive case studies on so many sensitive cases, so many intricacies of law, criminal, civil, the real life examples, including some hearings which are going on today and in the last few days. Really wonderful, inspiring thoughts, sharing experiences, a man of bold courage and integrity. Hats off to you. It's really wonderful to be part of this discussions with you, and we have done full justice to the time of 2 hours. Really excellent. Thank you so much. I now hand over back to the council of the institute for the final closure.
So we thank you so much, sir, Mr. Chand and Mr. Manoj, for taking this webinar in such a progressive way. And we thank you, sir, for sparing your valuable time and giving your insights to our participants. We would like to thank all the participants also on behalf of the Committee on Economic, Commercial Laws and Economic Advisory for attending this webinar. Thank you so much.
Thank you, Mr. Manoj, and thank you, Salini. Thanks, everybody.
Thank you, everybody.
Thank you, everyone.